together for us to make a little more sense, I will do that. If not, I'm just going to read through. I'm going to stay out of comments because it's a lot. We still have 60 some pages to go. If we can get through it all tonight, great. If we can't, we can't. Thank you, Angel, for the hand heart. That's what we're going over right now, Madison. It was a request of information that she did not provide, and we're just now getting into the request. No, you guys can talk amongst each other. Yeah, I like to have the comments on so you guys can talk, because people will have questions, and a lot of times you guys already know them, and so you can do that. No, if I turn the comments off, then you guys can't ask each other questions. My YT is the same as my TikTok, AngieW1470. Okay, here we go. Are you ready? Let me zoom this back in. Okay, so this is, respondent is Bree. Response to petitioner's demand. So this is her response. No, I was gonna, well, let me try. We'll screen record so I can try to get it up with the comments. Okay. Okay, here we go. Okay, respondent Brianna Lynn Olson's response to petitioner's demand for production of documents set 1. Do you guys want me to go back up and read what he requested or just go off of her thing? Let me ask you guys really fast. Click red if you want me to reread what he requested, blue if you don't. Red if you want me to reread what he requested, blue if you don't. It's going to be red, okay. Okay, it's not too much. Okay, I'm just going to start reading it then. Okay, because it's majority yes. Okay. Let me find it here. Okay, here we go. Okay, here we go. This is what he is requesting. Oh, I'm not going to read the definitions. Okay, documents and things demanded for production. This is what John has requested for Bree to provide. This was due over a month ago. She had 30 days to provide it. She did not provide it. They asked for an extension, and she was given either a 7 or 10 day extension and still has not provided it. So this is what he requested. 1, residence. Any and all documents evidencing your current, historic, and or any anticipated further residence, including, but not limited to, lease agreements, Airbnb rental contract, subleases, sub-rental agreements, any real estate property ownership documents, and rental and or purchase applications for any housing, lodging, residential address, apartment, and or home in which you have lived or intended to live from April 26th, 2024 through and including the date of production, which is current date. Number 2, lawsuits. Any and all documents related to any lawsuit you are or have been involved in, whether as a plaintiff, a defendant, petitioner, respondent, claimant, and or joint party, other than the instant parentage proceeding from April 26, 2024 through current. Airline travel. Any and all documents evidencing airline travel reservations, airline travel itineraries, airline travel schedules, payments related to airline travel by you and or the minor child from April 26, 2024 through and including the date of production. This demand shall also include documents relating to airline reservations made for you and or the minor child as of the date of production, but for which said airline travel has not yet occurred, meaning anything moving forward. Number 4, law enforcement records. Any and all documents included, but not limited to, reports, calls, call logs, and the like related to any events involving you, whether as the subject, a victim, or a witness, and any law enforcement agency since April 26, 2024. This demand shall include, but not limited to, all such documents related to any and all events involving you, and any law enforcement agency, police department, police officers, sheriff's department, sheriff's deputy, residential and or corporate security companies, residential and or corporate security personnel, private security personnel, and the like, while you were staying on Catalina Island in June 2025. So they're requesting the, on top of everything else, they're making sure they add it in to make sure we want all of the information of what happened at Catalina Island. Number 5, counseling. Any and all documents related to your enrollment, payment, progress, participation, attendance, and or completion of any counseling, therapy, and or co-parenting and or parenting courses, classes, programs, or seminars, including but not limited to any such programs or course at Cornerstone Counseling Center, and any and all documents evidencing your correspondence with are received therefore. That's for the parenting classes. Remember, she has to do the 12 weeks of parenting class. She admitted the other day online that she did the co-parenting class, not a parenting class. Number 6, travel to Texas. Any and all documents related to your lodging, travel arrangements, travel itineraries, and activities for your parenting time and or visits with the minor child in the state of Texas from April 2024 through and including the date of production. Number 7, any and all documents, including but not limited to correspondence reflecting and or evidencing the identity of any and all persons who have accompanied you and or who are anticipated to accompany you to the state of Texas, and or who have stayed with you and or who are anticipated to stay with you at your lodging at any point during your visitation and or parenting time with the minor child in Texas from April 26, 2024 through and including date of production. And the way I'm reading it, that guys, with the you and the your, is because those are capitalized. So I'm reading it as it's written. I don't want you to think that I'm just dramatically saying it. Yeah, Ruby, Santos, MJ, etc., whoever, right? Number 8, persons sharing household. Any and all documents evidencing the identity of any person or persons sharing your household. Number 9, relocation. Any and all documents related to your present or future relocation plans, whether within the county of Los Angeles or to any other location outside of the county of Los Angeles or the state of California. That is important because when we were reading the transcript, we went back over it a week or two ago, and it stated in there very clearly that she may be able to get visits in California if she still has a residence. Not if she's a resident of California, but if she still has a residence in California, which currently she does not. Number 10, correspondence. Any and all documents evidencing correspondence between you and any third parties related to the minor child and or the petitioner. Can you imagine the amount of documents she'd have? They're asking her to provide every single documentation to whoever she's speaking to in regards to baby W or 2K. She didn't take her DVRO very serious, and she's getting called out on it now. Number 11, impediments ability to travel. Any and all documents evidencing or relating to any present or future inability by you to travel to and from the state of Texas for your parenting time with the minor child. Number 12, travel within Texas. any and all documents written and correspondence between you and any members of your family reflecting, discussing, or otherwise referencing any family holiday plans you have or in which you desire to participate for the 2025 calendar year. Now, mind you, I turned that off. Why is that going on? Mind you, hey sister, this was done months ago. This was before the holiday season. This is being written up because she didn't respond. Because remember, the judge kept saying, you guys have to meet and confer, meet and confer, meet and confer. Well, John's attorney is trying to meet and confer, and she's not doing it. Bree's attorney. So this is Bree's response. Her attorney responds back and says, counsel attached for electronic service only per CCP 1010.6 are Brianna's response to John's RPDs and family law. So this is her response. Respondent Brianna Lynn Olson provided the following discovery responses based upon information presently available to and specifically known to responding party and are made without prejudice to further discovery. It should be noted that the responding party the responding party has not fully completed her investigation of the facts related to this case, has not fully completed her discovery in this action, and has not completed her participation or preparation for trial. All the responses herein are based only upon such information and documents which are presently available to and specifically known to the responding party, and disclose only those contentions which presently occur to the responding party. It is anticipated that further discovery, independent investigation, legal research, and analysis will supply additional facts, add meaning to the known facts, as well as establish entirely new factual conclusions and legal contentions, all of which may lead to substantial additions to, changes in, and variations from the responses herein set forth. The following responses are given without prejudice to responding parties' right to produce evidence of any subsequently discovered fact or facts which the responding party may later recall. Responding party accordingly reserves the right to change all responses herein as additional facts are ascertained and analyses are made. Legal research is completed and contentions are made. The responses contained herein are made in good faith effort to supply as much factual information and as much specification of legal contentions as are presently known, but should in no way be to the prejudice of responding party in relation to further discovery, research, analysis. I just remembered as I was reading this is why I wasn't keeping track. When we were reading before, John's attorney had said in the beginning that Bree only provided a expired lease agreement and that her attorney answered the questions. So I don't know yet because I'm a team player. I waited for y'all. I have a feeling this is going to be her attorney's response, which is not gonna fly, right? Let me plug my phone in. Give me 1 second here. Could you confirm Judge wants this info? This was done as a request from John's attorney. So I'm not sure if it's from I haven't got there yet on why it was requested, but we'll get there. We're just diving in. Okay, let's see here. Okay, except for explicit facts admitted herein, no indication or implication admissions are intended hereby. By responding to these demands, responding party does not waive any objections which would warrant exclusion of evidence if interposed at time of trial. And then it says, attorney's signature below is only as to the objection stated herein as required by California Code of Civil Procedure, and not a verification as to the response by responding party. Demand number 1, residence. Any and all documents evidencing your current historical and or I'll give you the brief because it gives you reads out the whole demand and then it gives the response. So we just went over all of them. I'm just going to tell you which one it is. I'm going to give them their answer. So this is the one for the residents for every place, including Airbnbs, hotels, everything from August of 2024 to current. Her response is, responding party objects to this request on the grounds that it seeks information that is irrelevant to the issues properly before the court in this parentage action and is not reasonably calculated to lead to the discovery of admissible evidence. The request seeks disclosure of responding parties' private, personal information unrelated to the child or to the issues of parentage, custody, visitation, or support, and therefore violates respondents' parties' constitutional right to privacy under Article 1, Section 1 of the California Constitution. The request is overboard, unduly intrusive, and appears intended to harass or embarrass responding party rather than to obtain relevant evidence. Accordingly, no response will be provided. Responding party objects to this demand as it seeks information protected by the constitutional rights of privacy of third parties who are not parties to this action. Responding party objects to this demand pursuant to CCP 2023.10 as this entire set of RPDs was served to harass respondent and retaliate against her due to her standing her ground on petitioners not micromanaging her time with W. On 9/16/2025, after respondent sent petitioner the address of her rental on OFW for her upcoming visit with W in Texas per the court orders, petitioner's counsel demanded numerous other pieces of personal information that respondent is not required to provide to petitioner, such as her flight information and itinerary with W. That actually is in their court records. I can read that. Anyways, just 1 hour after the attorneys stopped conferring about this topic via email, respondent's counsel was served with this discovery. These RPDs seek a laundry list of personal information, and the respondent with the petitioner has no right to. Yeah, it does say actually in there for her visitation time, she is to provide him with all flight information, where they're staying, full itineraries, everything. It states that in the court doc, so I'm not sure what she's talking about. Demand number 2, which is the lawsuits that he's requesting. I have a feeling they're going to object to everything. So the response for demand number 2. Responding party objects to this request on the grounds that it is seeking information that is irrelevant to the issues properly before the court in this parentage action and is not reasonably calculated to lead to the discovery of admissible evidence. This request seeks disclosure of responding parties' private personal information unrelated to the child or to the issues of parentage, custody, visitation, or support, and therefore violates respondents' parties' constitutional right to Privacy Act under Article 1, Section 1 of the California Constitution. If it keeps saying that, I'm gonna say on repeat, and it's gonna be this exact same thing, basically stating that they think it is against their constitutional right to say it. So I won't read that entire thing. No, this is Brian 2K. The request is overboard, unduly intrusive, and appears intended to harass or embarrass responding party rather than to obtain relevant information. Accordingly, no response will be provided. Responding party objects to this demand on the grounds that the documents requested are equally and more available to the petitioners through LASC SC's website, Los Angeles Sheriff's County website, pursuant to Ryan v. Superior Court of Los Angeles, 1960, blah, 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 blah. Respondent is not required to prepare the case of her opponent at her expense. Responding party objects to this demand pursuant to CCP, and this entire set of RPD was served to harass respondent and retaliate against her due to her standing her ground on petitioners not micromanaging her time with baby W. On 9/16/25, after respondent sent petitioner the address of her rental on OFW for upcoming visit, the court it's the exact same thing. So I won't read that each time. I'm not going to bore you guys with the same words, okay? Right. Who said that? Right. Broke, but in Paris. Go figure. Number 3. This is his request for the airline travel. Her response is, responding party objects to this request on the grounds that it seeks information that is irrelevant, the exact same thing. Let me see. Responding party objects to this demand, seeks information protected by the constitutional right. Responding party objects on this demand on the grounds that the documents requested as respondents' flight information are equally and more available to petitioners through prior emails respondent has sent to the petitioner's counsel since the inception of the case, containing screenshots of respondents' flight information. Because she is required to do that. These documents are brand new. They just came out. She does have to provide him with the verification of her flight information. And then it goes right into that she's not going to do it because she feels like because he's mad. Because she thinks he's trying to control things. Number 4, this is the law enforcement records, okay? That's any and all document law enforcement information, reports, call logs, etc. of anything that she has been involved in. And her response is, responding party, guess what she does? You guessed it. She objected. Responding party objects to this request on the grounds it seeks information that is irrelevant to the issues properly before the court in this parentage action and is not reasonably calculated to lead to the discovery of admissible evidence. The request seeks disclosure of responding party's private personal information unrelated to the child or the issues of parented custody, visitation, or support, and therefore violates her First Amendment. So I won't read all of that. Responding party objects to this demand on the grounds of the documents requested are equally and more available to petitioner through LASC's website. Responding party objects to this demand as it seeks information protected by her constitutional right. And then once again, she uses the same phrase. I'll read it one last time. Responding party objects to this demand pursuant to CCP 2023.010 as this entire set of RPDs was served to harass respondent and retaliate against her due to her standing her ground on petitioners not micromanaging her time with W. On 9/16/25, after respondent sent petitioner the address of her rental on OFW for her upcoming visit with W in Texas, per the court order, petitioner's counsel demanded numerous other pieces of personal information that respondent is not required to provide to petitioner, such as her flight information and itinerary with W, just 1 hour after the attorney stopped conferring about this topic via email. Respondent's counsel was served with this discovery. The RPDs seek a laundry list of personal information on respondent and petitioners that has no right to. So that's what she says on everything. So I won't read that every single time. I'll just let you know if that's what they say, which it is. Number 5, counseling. This is the one that's in regard to the her taking her parenting classes. I keep turning this off. How does it keep coming back on? Oh, here we go. Now I turned off my request. Okay. So counseling, here's her response. Responding party objects to this request. Now, this one blows my mind as to why they're objecting to this because the judge ordered her to take 12 weeks of a parenting class. Bree said, "Oh, Your Honor, I did." But she didn't. She took a co-parenting class. She just admitted it actually last week on live. She took a co-parenting class, which we all knew. She has not taken her parenting classes, so I don't know why they're objecting to this when the court ordered her to take the parenting class. But nonetheless, I'll read. I'll read his demand too, just for anyone who's new here. This is what the demand was. Counseling, any and all documents related to your enrollment, payment, progress, participation, attendance, and or completion of any counseling, therapy, and or co-parenting and or parenting courses, classes, programs, or seminars, including but not limited to any such programs or courses at Cornerstone Counseling Center, and any and all documents evidencing your correspondence with or received therein. Again, she was court-ordered by the judge. That had nothing to do with Duque. So this is her response. Responding party objects to this request on the grounds that it seeks information that is irrelevant to the issues properly before the court. It's the exact same thing. I don't know how it's irrelevant when the judge ordered it. But I won't read all that. She's just saying, under the California Constitution, she doesn't have to do anything. Responding party objects to this demand on the grounds of doctor-patient privilege. That would make sense if it was like a personal therapy session, but again, he's focusing on I'm assuming on the parenting classes. Responding parties objects to this demand as it seeks information protected by the constitutional right of and it scared the crap out of me. What the hell was that? Oh, thank you, love. That scared me. Responding party objects to this demand as the entire set of that's the same thing. That this is the one that said to harass the respondent in retaliation because she stood her ground by not providing the information she was required to. Demand number 6 was travel to Texas. That was any and all documents related to your lodging, your travel arrangements, travel itineraries, activities for your parenting time, and or visits with the minor child in Texas. This is her response. Responding party objects to this request on the ground that it seeks information that is irrelevant to the issues properly before the court in the parentage action and is not reasonably calculated to lead to discovery admissible. How is that irrelevant? I'm so confused. Court is January 6th. I'm so confused on how that is not relevant. That's what it's for. But nonetheless, I'll just shut up and read. The request seeks disclosure of respondent parties' private personal information unrelated to the child or to the issues of parentage, custody, visitation, or support, and therefore violates respondent's party constitutional right under 1.1, whatever. The responding party objects to this demand as it seeks information protected by the constitutional right of privacy, whatever. And then it goes right back into the same sentence that she feels like he's doing this because she refused to follow the law last time she had him. Or in September. Because remember, this is old. This was requested. It was due back in October. They got an extension, and they're still fighting it. Number 7, any and all documents included but not limited to correspondence reflecting and or evidencing the identity of any and all persons who have accompanied you and who are anticipated to accompany you to the state of Texas. So this is him asking for verification of who is coming to her visits with her. Guess what she did? You guess it. She objected. Literally, that's what I want to say. Copy, paste, copy, paste, copy, paste. She objected under the exact same rule. Responding party objects to this demand on the grounds that the documents requested are equally and more available to petitioner. As he already knows, it has only been respondent's mother present at the visitations with W in Texas back in May of 2025. As petitioner had to approve this through the professional monitoring company. But that's not what he asked. He didn't ask that. He asked who has traveled with her. Because remember, when we read back in the transcript, the judge said Santos is not to be there under any circumstance at all. And I went into the California state law website and looked up what does that mean. And that means not a part of in any way, shape, or form. It is a broad meaning he can't be on the phone, he can't be on FaceTime, he can't go into the residence where they're at, even if they're not there. He can't be in the yard, he can't be in the car outside. You know, I feel like I'm reading like the Cat in the Hat book, you know. So that's what the rule states, and now she's saying that's let alone next door, stopping by, picking Chrome up, the whole nine. Anyways. And then they go on to their favorite phrase about the 916 where she stood her ground. Demand number 8, persons sharing household. Any and all documents evidencing the identity of the person sharing your household. Guess what she did? You guys are so smart. She objected under the same rule. Responding party objects to this demand as it seeks information protected by the constitutional right. Responding party objects to this demand, again, stating that after 916 where she stood her ground, that's why he's asking. Number 9, relocation. Any and all documents related to your present or future relocation plans. Her response, you guessed it, she objected. That's what I thought I was reading, was green eggs and ham. Yes. She objected. Responding party objects to this request on the grounds as it seeks information that is irrelevant to the parenting issues. I'm not going to read all that again. Responding party, same thing. Objects, again, under the 9. When we get to this part, the 916, 2025, I'm just going to say 916, so you guys know. Okay, response number 10, correspondence. Any and all documents evidencing correspondence between you and any third party related to the minor child and or petitioner. And she objects. She objected. Yep, again. Responding party objects to this request on their grounds that it seeks information that is irrelevant to the issues properly before the court in the parentage action and is not reasonably calculated to lead to the discovery. This request seeks disclosure of responding parties' private personal information. I will say, I don't know how somebody would provide all of that information. I think if it was like to specific people, but I don't know how anybody, how one would provide all documentation of anybody that they talk to about them. You know what I'm saying? Sorry, I'm trying to keep my voice from going out. Yeah, like emails, text, like that kind of stuff. That would make sense. I think so. I think it will look bad on her. But let me see. But we're going to get to the good stuff. We're only on page 31. There's 90 pages. And in the very beginning, when I was reading over it, his attorney stated that her attorney did all of this. She didn't. So, responding party objects to this demand on the grounds that the documents requested are equally and more available to the petitioner as communication to form him. He doesn't want to talk to, it's not about their communication. And then we got the 916 rule. Demand number 11. Impediments ability to travel. This is because, remember, she said because she's so far along in her pregnancy. T-Junkie's here. Hi, love. She's so far along in her pregnancy. 6 weeks and 1 day still. He wants verification of that to see why, baby W should have to do all the traveling for her. Well, golly gee willikers, you are not going to believe this. She objects. She objects. Again, thank you, sister. My shitting tree. Thank you, sissy. How would you object? This is the one thing that she wanted. She said she was going to be so far along in her pregnancy, it was going to be hard for her to travel, which is why she wanted baby W to have visits in California. But if you guys remember, and if you guys are on earlier, you do, the transcript said that she may be able to have visits in California if she has a residence in California, which right now she does not. Nor is she far along in any pregnancy. So, and she objects to provide the verification. So we'll read through it. Responding party objects to this request on the grounds that it seeks information that is irrelevant to the issues probably before the court in this parentage action, and is not, that doesn't make any sense to me. But anyways, it's the exact same thing. Responding party objects to this demand as it seeks information protected by the constitutional right, and then we have the 916 objection again. That's crazy. Demand number 12 was travel within Texas. Any and all documents, writings, and correspondence between you and any members of your family. She objects. Same thing. Responding party objects to this demand as it seeks information protected by her, and then the 916 objection. And that was the end of her responses. We're only on page 34. Buckle up. So they provided absolutely nothing. All right, so let's move along now. This is respondent's proof of service. Number 1, I am employed at the law office of Arthur Kahn. This is from Bree's attorney. 2, I am over the age of 18. Number 3, oh wait. Yeah, it is. Sorry, I just want to make sure. 3, on October 22nd, 2025, I served the foregoing documents bearing the title. Number 1, respondent's response to petitioner's family law firm. Number 2, respondent's response to petitioner's request for production of document set 1. And then it says, she did it by placing true copies, therefore enclosed in sealed envelopes addressed as follows, and then served them via electronic email. And then she signed it. And that was on October 22nd. And now we're going to go to Exhibit C. Exhibit C is an email from John's attorney to Bree's attorney. It says, good afternoon. Please see the attached correspondence from our office below. Should you have any questions, please do not hesitate to contact our office. Best regards. Electronic service. Here's an email from, I'm assuming this email. Oh, this is the letter. Okay. This is from John's attorney to Bree's attorney. I just call her Miss F. Dear Miss F, the purpose of this letter is to meet and confer with you regarding your client's response to petitioner's demand for production of documents, set 1, which response are comprised solely of objections and were served to my office on October 22nd, 2025 via email. Demand number 1. Again, I won't read through all of this again, each demand. So demand number 1, member, is the residence, all documents of all residents that she's been at from April of 2026 to current, including Airbnbs, hotels, all of that stuff. Respondent's response was an objection. Responding party objects to this request on the grounds as it seeks information that is irrelevant. Oh, come on. It puts that out, and then documents provided, none. Reason, and then this, so now we're getting John's attorney's response to their objections. Okay, so number 1, reason to compel further response. The issue before this court include custody, visitation, parenting time, and co-parenting orders, as well as a move-away order. Did you hear that, Bree? As well as a move-away order. Because I know she made a video the other day saying, you guys, there is no move-away order. We're not doing that. You should read your documents that you get, Bree, because this is also regarding a move-away order. Anyways. Documents evidencing respondent's residential history since the minor child's birth is relevant to the issue of custody in that it is reasonably calculated to lead to the discovery of admissible evidence regarding respondent's ability or lack thereof to provide stable and suitable housing for the minor child if awarded custodial time at her residence. Hello. Respondent's current residential information is relevant to the issue before the court, as respondent is seeking orders granting her the ability to exercise parenting time with the minor child at respondent's residence. Well, no present hearing on any, next page, request for pendant light, child support, or attorney's fees on calendar. Respondent's historic and current lease agreement, rental application, etc. are all also reasonably calculated to lead to the discovery of admissible evidence related to respondent's financial ability to pay child support, attorney's fees, or even contribute to travel expenses for visits with the minor child. Child support and attorney's fees are among the issues that may arise over the course of this parentage action. The request is narrowly it's a hard one, narrowly tailored to only seek information for the time period that the instant parentage proceedings has been pending. The information sought is not unduly intrusive, moreover, intrusive. Is not a valid objection to a request for production of documents. Respondent and petitioner share a child together. Respondent has no reasonable expectation of privacy with the respect of her residential history. This demand is not intended to harass respondent. Further, the information sought by this demand is not embarrassing. Petitioner and respondent share a child together. The issue of where the minor child will live is presently before the court. Parents have an interest in knowing where their child has lived, is living, or will be living that outweighs any interest in privacy respondent may otherwise have in any residential history since the minor child's birth and are going forward while the court continues to have custody jurisdiction over the minor child. Respondent can redact information that violates the constitutional rights to privacy of third parties to the extent any such information is contained on the documents requested. The final paragraph of the respondent's objection in argument by counsel. It is entirely devoid of a code-compliant discovery objection and must be removed. Respondents' objections are not appropriate or valid and must be removed. The supplemental response and production of all responsive documents in respondent's possession, custody, or control must be produced. Demand number 2, which is the lawsuit 1. And then it also lists out her objection, which we will not read. And then documents provided, none. So I'll tell you each objection or each demand again, and then I'm only gonna read the attorney's response. Okay, that will help us out. Reason to compel further response. The issue before this court includes custody, visitation, parenting time, and or co-parenting orders, as well as a move-away order. I'm going to keep saying that one too. Documents evidencing respondents' involvement in any other lawsuits are reasonably calculated to lead to the discovery of admissible evidence regarding respondents' parental fitness. Respondent is seeking orders granting her the ability to exercise parenting time with the minor child at respondent's residence. Lawsuits in which respondent is facing eviction, for example, would be relevant to the issue of whether respondent can provide a suitable and stable residence for the minor child. Lawsuits in which respondent is the perpetrator of DV against someone other than petitioner would likewise be relevant to the custody issues before the court. Lawsuits in which respondent is facing jail time would be relevant to the court's determination about whether to award respondent custodial time in her state of residence. Lawsuits in which respondents may be entitled to monetary awards and relevant to financial issues. While no hearing on financial issues is presently on the counter, issues of attorney's fees and child support add-on expenses are ordinarily among the issues resolved in the final parentage judgment. The request is narrowly tailored to only seek information for the time period that the instant parentage proceedings has been pending. The information is not unduly intrusive, moreover intrusive, is not a valid objection to a request for production of documents. Respondent and petitioner share a child together. Respondent has no reasonable expectation of privacy with respect to the requested information. Respondents claim that the information is equally available to petitioners through LASC website is not an appropriate objection on this demand. This demand is not seeking documents related to the parentage case between respondent and petitioner, so the requested information is not, in fact, available to petitioner through LASC website. This demand is not intended to harass respondent. Further, the information sought by this demand is not embarrassing. Moreover, the document would corroborate information requested by the family law interrogatories. The final paragraph of the respondent's objection is argument by counsel. It is entirely devoid of a code-compliant discovery objection and must be removed. Respondent's objections are not appropriate, invalid, and must be removed. A supplemental response and production of all responsive documents in respondent's possession, custody, and control must be proceeded. I have a feeling that's going to be probably on that last paragraph that I read is probably going to be on every single one. And so I will do the same by skipping over that. Okay. Demand number 3. This is the airline travel that he was requesting. And he was only requesting airline travel for Bree and baby W. Okay. In this one. Number 3. And again, she objected. Documents provided, none. And then this is counsel's response. The issue before this, again, this is always going to be the same too. The issues before this court include custody, visitation, parenting time, and co-parenting orders, as well as a move-away order. Documents evidencing respondent's travel since the minor child's birth and anticipate further travel are reasonably calculated to lead to the discovery of admissible evidence regarding respondent's request for the minor child to reside with her in the state of residence, for example, as well as any claims respondent may or may not raise regarding difficulties traveling to Dallas, Texas to exercise parenting time in the minor child's current home state, among other issues. Respondents' expenditures on travel are also relevant to financial issues. Side note, I do have a feeling that this is coming up because if by chance she does get to have the travel, it's going to go back to who's going to pay it. Typically, when it's an out-of-state parent, in most cases, again, I'm not in California or Texas, but each parent will pay one way. But he has spent the majority of the time paying for all travel expenses. Right? And so I have a feeling that that's why they're bringing it up now, is they're going to show that he has continuously, besides just the past, 4 months, maybe 5 months, he has paid all travel expenses, housing, absolutely everything. So that's why this is important. Anyways, while no hearing on financial issues is presently on calendar, this is the same thing. The attorney's fees, child support, and child add-on expenses will at a later time. This request is narrowly tailored to only seek information for the time period that that the instant parenting proceedings has been pending. This information sought is, this is the same one, same paragraph, so I won't read that again. It's not intrusive. It's intrusive. It's not a valid objection. It's not embarrassing. Respondent can redact information that violates the constitutional rights of privacy by third parties to the extent any such information is contained. Give me 1 second. Please hold on. Hold on. Sorry, I just got a message. One of my grands is sick. I need to make sure everything's okay. Okay. Okay, number 4, law enforcement records. That was the demand, was for all the law enforcement records. And as we know, she objected. We could have played it. The issue before this court included, and sorry, this is the response. No documents provided. Reason to compel further response. This is John's attorney's response. The issue before this court, hold on. I apologize, guys. Sorry. I have a sick baby. Hold on. Okay. Sorry. Come on. It's your turn. Okay. All right. Let me go back up. Make sure we're on the same one. Okay, this is the law enforcement one. She provided none. The issue before this court, again, includes custody, visitation, parenting time, co-parenting. Okay. Got it. Okay, all's good. Documents evidencing respondents' involvement with law enforcement since a minor child is birth is reasonably calculated to lead to the discovery of admissible evidence regarding respondents' parental fitness and the health, safety, and welfare of the minor child while in the care of the respondents. It is also reasonably calculated to lead to the discovery of admissible evidence regarding DV incidents between respondent and her current or former partners. Respondent is seeking orders granting her the ability to exercise parenting time with the minor child at respondent's residence. Documents such as police reports reflecting law enforcement involvement into incidents in which respondent or a romantic partner of respondent has been arrested and or suspected of perpetrating DV is relevant to and or reasonably calculated to lead to the discovery of admissible evidence relevant to the custody issues before this court. The request is narrowly tailored only seek information for the time period that the instant proceedings have been pending. This information sought is not, this is the whole not intrusive thing and it needs to be removed. Respondent's claim for this information is equally available to the petitioner through LASC's website and or subpoena is not an appropriate objection to this demand. This demand is not seeking documents related to the parentage case between respondent and petitioner, so the request information is not, in fact, available through petitioner through LASC website. Petitioner cannot be expected to issue subpoena to each and every law enforcement agency in the country as a fishing expedition to see if respondent has had any involvement or not. Not a fishing expedition. Oh my God. For everyone that is just, well, I'll finish this and I'll do that. This demand is not intended to harass the respondent further. The information sought by this demand is not embarrassing as they have a child together. We read that each time. They're expected to co-parent. Respondent can redact any information that violates the constitutional right. The final paragraph of the objection in argument by counsel is entirely devoid of code-compliant discovery objections and must be removed. Respondent's objections are not appropriate or valid and must be removed. So we're getting ready to go on to demand number 5. Hello to everybody that is here, that has joined us. If you are not already following, please make sure you hit the follow button. I will be breaking this down. We still have a long ways to go. It's 90 pages total, and I think we're on page like 40. So we still have a ways to go. I also will be Thank you for following, you guys. I also do have a YT page. It's the exact same names. Exact same name, Angie W1470. I will put this up over because I know it's late. So I will put this up over on YT as well. And then I will work over the next day or two on doing videos breaking down each one of these and trying to, you know, make a little more sense, because I'm kind of trying to rush through it. But I would just want to make sure I let you guys know. And anything that's like repetitively, I'm skipping over. So just so you guys know. Okay, demand number 5. This was for the counseling. If you guys remember, she was required to do 12 weeks of parenting classes, and she has not done them, and she objected to providing that information. So that was demand number 5, is requesting for that. Can I do... I'm not going to do a quick... Yeah, I'm not. There's nothing quick about doing a recap. Maybe at the very end I can, but right now I'm just going to flow through. Yep, it'll be on YT tomorrow. Yeah, promise. Okay, so yeah, so they requested verification of the parenting classes she was required to do, and they objected. So, okay, documents provided, none. And then this is John's attorney's response. The issue before this court includes custody visitation, parenting time, and co-parenting orders, as well as a move away. Documents evidencing respondents' completion of a co-parenting or parent class or other counseling or program is relevant and or is reasonably calculated to lead to the discovery of admissible evidence regarding custody. The court ordered respondent to complete such counseling. Petitioner is seeking documents related to respondent's alleged enrollment, participation, and completion of the same. The request is narrowly tailored to only seek information for the time period that the instant parentage proceedings has been pending. The information sought is not duly intrusive, is not a valid objection request for production of documents. Respondent and petitioner share a child together. Respondent has no reasonable expectation of privacy with respect to this information. This demand is not intended to harass. That's that whole, I won't repeat that because we do it at your time. Respondent's objection that the information sought is protected by doctor-patient privilege is not appropriate given the limited information sought by the demand. This demand seeks enrollment, payment, progress, participation, attendance, and or completion documents. It does not seek information regarding medical diagnosis, treatment, etc. Moreover, respondents' progress reports obtained in connection with a co-parenting or parenting program are not protected by doctor-patient privilege. Respondent can redact information. This is the whole thing, redacting all the information. Respondent's objections are not valid and must be removed. Okay. Demand number 6 was the travel to Texas. This was any and all documents related to your lodging, travel itineraries, etc. to Texas from April to current. And of course, she objected. No documentation was provided. This is John's attorney's response. The issue before this court includes custody visitation, parenting time, co-parenting orders, move away order. Documents evidencing respondents' travel since the minor child's birth, anticipated future travel are reasonably calculated to lead to the discovery, of admissible evidence regarding respondent's request for any minor child to reside with her in the state of residence, for example, as well as any claim respondent may or may not raise regarding difficulties traveling to Texas to exercise parenting time with a minor child, current home state, among others. Respondents' expenditures on travel are also relevant to financial issues. While no hearing on financial issues is presently on calendar, issues of attorney's fees, child support, and child support add-on expenses are ordinarily among the issues resolved in the final parentage judgment. Documents evidencing excuse me, documents evidencing respondents' participation in activities with the minor child during her visits in Texas are reasonably calculated to lead to the discovery of admissible evidence regarding the best interests of the minor child, his bond with respondent, and respondent's bond and ability to care for the minor child. The request is narrowly tailored to only seek information for the time period and said. The next paragraph is the intrusive one. It shouldn't be embarrassing because they share a child in common. Respondent can redact the information of other people. Respondents claim this information has been provided via email to counsel is insufficient to absolve respondent of answering this demand and producing documents. Respondents' counsel email to petitioner's counsel do not amount to verified response signed by respondents under penalty and perjury of law, and this demand seeks information beyond respondents' travel itinerary to and from visits. The final paragraph of respondent's objection is argument by counsel is entirely devoided. And that's the whole same thing. Okay, I'm going to take a quick drink and then we're going to go on to number 7. It's a lot. And sorry guys, I'm not reading comments because I'm really trying to just stay focused and get us through this, okay? I appreciate all of you guys hanging out with us. Make sure you hit the follow button and in your daily heart me. We're good. Okay, number 7. The demand was any and all documents included but not limited to correspondence reflecting and or evidencing the identity of any and all persons who have accompanied her to Dallas. Yes, thank you. I did see that. Who said that? Missy. Yeah, keep it cute in the comments. Listen, we all don't have to all have the same opinions. We don't all have to agree, but you do have to keep it cute in the comments. Okay, if we can't keep it respectful, then mods know what to do. Okay. Again, she objected. And no documents were provided. And then this is John's attorney's response. Me too. Excuse me. The issues before this court includes, again, the custody, visitation, parenting time, etc. I'm not going to read all that. And the move-away order. Documents evidencing third-party accompany respondents' travel to Texas and or staying with respondent at her lodging in Texas for respondent's parenting time are reasonably calculated to lead to the discovery of admissible evidence regarding custody. Respondent's compliance or lack thereof with court orders, respondent's credibility, the minor child's bond or lack thereof with friends or family members of respondent, or any claims respondent may or may not rise regarding difficulties traveling to Dallas, Texas, to exercise parenting time with the minor child's current home state, among other issues. Respondents' expenditures on travel are also relevant to the financial issues. Again, it goes on to the whole thing about they're not talking about it now, but they will. The request is narrowly tailored to only seek information for the time period that the instant parentage proceedings have been pending. The information sought is not unduly intrusive, moreover intrusive. Again, that's that whole statement. We'll skip over that. Respondents claim that the information has been provided to petitioner because he had to approve her mother attending a visit in May of 2025 is insufficient to absolve respondent of answering this demand and producing documents. Respondent is required to provide verified responses signed by respondent under penalty and perjury of this demand, and this demand seeks information beyond respondent's mother's attendance at a May 2025 monitored visit. Respondent can redact information that violates the constitutional right to privacy or third parties. Same paragraph. The final paragraph objection is devoided and needs to be removed. Respondent's objections are not appropriate, invalid, and must be removed. Demand number 8. Mama Lou! Okay, demand number 8, persons sharing household. Any and all documents evidencing the identity of any person sharing your household. And again, she objected. Documents provided, none. And this is John's attorney's response. Again, it starts out with the issue of the court is for custody visitation, co-parenting, and the move away order. Documents evidencing the order, persons sharing respondents' residence are relevant to the custody issues before the court. This information does not violate respondents' right to privacy in any capacity and is the type of information that is routinely disclosed in family law proceedings, including FL-150 forms and responses to forms interrogatories family law. This information is also relevant to respondents' credibility and compliance with court orders. In that, respondent has historically made representations about persons sharing their household, and existing orders prohibit certain individuals from being present during respondent's visit with the minor child. Oh. The request is narrowly tailored to only seek information for the time period that the instant parentage proceedings has been pending. The information sought is not unduly intrusive. This is that whole paragraph. I won't read that again. This demand is not intended to harass respondent. Further, the information sought by this demand is not embarrassing. They have a child together. The documents requested do not violate the constitutional right. So this is that's their whole same paragraph at the end. So I'll read that. Okay, demand number 9 is the relocation. Any and all documents related to your present or future relocation plans, whether it's in or outside of Los Angeles. And again, she objected. Verification provided, none. This is John's attorney's response. It starts out with the same. The issue before this court includes custody, visitation, parenting time, co-parenting, and thank you, love, and a move away order. Documents evidencing respondent's relocation plan is directly relevant to the move away order or move away issue before this court. This type of information is also reasonably calculated to lead to the discovery of admissible evidence relating to other issues in the parentage proceedings. The request is narrowly tailored to only seek information related to respondents' imminent and anticipated future relocation plans. The information sought is not unduly intrusive. Okay, same paragraph. The demand is not intended to harass the respondent. Further, the information sought by the demand is not embarrassing. Petitioner and respondent share a child together. The issue of where the minor child lives is presently before the court. Facts. Respondent can redact information. You'll know that. And the final paragraph of the objections all need to be removed. Okay, demand number 10 is correspondence, and this is any and all documents evidencing correspondence between you and a third party in regards to the minor child or John. And again, she objected. No verification was provided. And then this is John's attorney's response. The issue before this court, again, includes custody, visitation, parenting time, co-parenting, and move away order. Documents evidencing respondents' communications about the minor child and or the petitioner are relevant to the issues before this court and reasonably calculated to lead to the discovery of admissible evidence in this proceedings. For example, respondents' communication about petitioner relate to the relationship between the parties, including whether respondent disparages petitioner, speaks to respondent's ability or lack thereof to co-parent. Documents reflecting respondent's communication about petitioner and or the minor child are also reasonably calculated to... Thank you, T-Junkie! Thank you so much, love. Reasonably calculated to lead to the discovery of admissible evidence regarding respondent's compliance or lack thereof with the court orders. Such documents are also reasonably calculated to lead to the discovery of admissible evidence related to respondent's credibility which is always at issue. I'm going to read that again. Let's read that one more time. Such documents are also reasonably calculated to lead to the discovery, of admissible evidence related to respondents' credibility, which is always at issue. Oh, okay. Respondents' communication about the minor child are also directly relevant to the custody issues before the court. The request is narrowly tailored to seek information during the time of the case. Then it's the intrusive one. We go over that. This demand is not intended to harass respondent. This request is not harassing. Further, the information sought by this demand is not embarrassing. Respondent can redact information of other people. The demand is not seeking respondent's communication with petitioner. Accordingly, the objection that the requested documents are equally and already available through OFW, and then again the last one where they redact them because they're wrong. Demand number 11. Let me take a drink because this is a lot. Okay, demand number 11. Impediments to ability to travel. This was how she said she wasn't going to be able to travel because she's late in her pregnancy. And she objected to that. She provided none. And then this is the, thank you guys all so much for the gifts. I really do appreciate you guys all. This is John's attorney's response. The issue before this court includes custody, visitation, parenting time, co-parenting, as well as move away order. Documents evidencing respondent's ability or lack thereof to travel are directly relevant to the determination of a visitation/parenting time schedule, as well as the location of respondent's visit or parenting time. The request is narrowly tailored to only seek information of the time period for that instant. Parenting proceedings has been pending. The information sought is not unduly intrusive, moreover intrusive, we know that. The demand is not intended to harass respondent. Further, the information sought by this demand is not embarrassing. Petitioner and respondent have a child together. The issue of where custody, visitation, and parenting time will be exercised is presently before the court. Respondent can redact any information from other people. However, it is unclear how a demand for documents evidencing respondent's ability or impediments to her ability to travel impact the privacy rights of the third parties in this capacity. The final paragraph of the object, all that needs to be removed, as we talked about before. Number 12. This was his demand for travel within Texas. Any and all documents written and correspondence between you and any members of her family reflecting, discussing, or otherwise referencing any family holidays that you had. She objected. She provided none. This is his response. Starts out with the same thing. The matters before the court for the move away order, etc. Documents evidencing respondents' family holiday plans are reasonably calculated to lead to the discovery of admissible evidence related to the move away issue, as well as the custody and visitation issues broadly. For example, in connection with any analysis of the La Musca factor, a minor child's relationship with the community and or extended family members is often among the type of evidence that is relevant. This demand is intended to obtain information about the minor child's bond with the respondent's family members and the extent to which there is a need for the court to ensure the minor child is able to continue participating in holiday traditions on either side of the family when determining a holiday and vacation schedule. That makes sense. The request is narrowly tailored. We know that. Then you got the intrusive issue. It's not embarrassing because they have a child together. The demand for information about respondents' families' holiday plans does not violate the privacy rights of third parties. The final paragraph, objected, needs to be removed. Then it says, your client's aforementioned unmeritorious objections to petitioner's demand for production of documents set 1, coupled with her refusal to produce any documents whatsoever, constitutes a misuse of her discovery process and is among the type of conduct that is subject to sanctions. Your client is requested to provide supplemental responses with all unmeritorious objections removed and produce all responsive documents by no later than close of business 5 p.m. on Wednesday, November 26th. Please be advised that I have not received satisfactory responses and documents production by close of business on Wednesday, November 26th. I will proceed with filing a motion to compel your client's supplemental responses and production of responsive documents and seek monetary sanctions against her for my client's fees incurred in connection with compelling your client's supplemental responses and production of responsive documents. The one thing that I hate about reading court docs is I feel like they just say like the same thing like over and over and over and over and over and over and over. So, okay, I'm gonna take a drink. My throat's, my voice is barely hanging on. I just got it back. But for y'all, I'm gonna lose it again, okay? Okay. Here's another email. I love the emails. This is from John's attorney. Good morning, all. We are in receipt of your meet and confer letter on Miss Olson's response to demand for production of documents. Our office will be closed next week for the holidays and therefore will not be able to comply with the requested deadline. Therefore, we are requesting an extension from your Wednesday 11/26 to 12/8. Additionally, I apologize. This is from Bree's attorney. I apologize, not John's attorney. I was confused from him. So they asked for an extension from 11/26 to 12/8. Additionally, Miss Olson will be traveling for the holidays to CW during Thanksgiving week and will not readily be available to complete your request when she is out of town for her set visitation. Okay, now this is in response. This email is from John's attorney. Hi, confirming my phone call with Kristen a moment ago. We are in agreement with extending the supplemental response deadline from November 26th to December 8th. And my motion to compel deadline to the extended applicable, given that the original responses consist solely of objections or are not verified, will be afforded a reciprocal extension of time. Happy holidays. And then she responds back, thank you and happy holidays to you as well. And this is from this is from Bree's attorney. Counsel, attached is our formal response to your 11/19/95 meet and confer letter, Brianna's response to John's RPDs, and a copy of Brianna's last lease that just expired a few weeks ago. This is another email, or no, this is... Okay, this is her response. Discovery responses. Here we go. Hi, Taylor. This letter shall serve as our formal response to your 11/19/25 meet and confer letter, RE, Brianna's response to John's request for production of documents set 1, which were served to our office via email 10/22/25. In sum, we're not Jesus. I try to just read. Literally, it says, first sentence, In sum, we're not providing supplemental responses. Like, can they do that? And we stand by our objections. We still believe these demands were served for the improper purpose of annoying and harassing Brianna pursuant to CCP 2023.010. Both parties have now wasted hours of time and thousands of dollars in attorney's fees over this frivolous discovery, which is sanctionable conduct pursuant to FC 271. This lady. Service of these demands occurred just 1 hour after we refused your email demand for much of the same stuff your RPDs asked for. And you refused to point me to where in the DV 130 you were claiming there were kidnapping orders that justified your informal demands. What? Again, there were no such orders on the last page of that form per what you claimed in your email. The timing of this service of these demands was no coincidence. It was retaliation for not getting what you wanted via email. And what you wanted wasn't anything John was entitled to under the DVRO. I will remind you that you admitted that in your 9/17/25 response, claiming you were personally concerned about Brianna's unsupervised visits with W and didn't want to be held liable by your client for anything that happened. As I said in my response that day, you can't create orders that don't exist just to appease your client. That's completely inappropriate. Then she puts it, look at this, in all caps, in red, underlined. If you proceed with filing a motion to compel further responses, we will respond with requesting at least $10,000 in sanctions pursuant to FC 271 and CCP 2023.010 and 2023.030. What? Maybe almost made me spit my drink out. I'm gonna start drinking Diet Coke again. Okay, well, here we go. Let's read them, shall we? Okay, we're going back to Demand 1. Demand 1, residential documents. No supplemental response will be provided, as John already has Brianna's historical address information since W's birth as required by law. As evidenced, as evidenced by documents on file with the court, Brianna's addresses are all he is entitled to. We remain concerned with the ease at which Brianna's Airbnb addresses in Dallas keep being visited by third parties during her visitation with W when only John and her have those addresses. Because she goes live from the places. She lets everybody know where she is. That's no mystery, lady. Just turn on your thing. But anyways, the fact shared in our objection that cited to the CCP were to highlight why we believed this entire set of discovery was served for the improper purpose of harassing and annoying Brianna. God forbid. You demanded information from Brianna about her first non-supervised visitation with W that was far outside the scope of what was required to provide per the DVRO. When I asked you to explain what part of the DVRO you were relying on to demand this information, you could not provide that information to me because it doesn't exist within the DVRO. Thus, We still stand by the belief that John only served this discovery just 1 hour after we declined to provide what you demanded via email as a means of harassing my client. John's 43024 UCCJEA forms list. The UCCJEA is it's like a form in a database when children move across state lines. It's how they keep track. Okay. Form lists Brianna's address that she lived at during the time of W's birth. I won't release the address, but it's on here. John visited Brianna and W at this address multiple times. Brianna's next address, oh my God, sorry. Brianna's next address was at the MILF house. I shit you not. I would show you, but the other address on here. She literally put on there was at the MILF house. Didn't even put the address. She literally put was at the MILF house. I can't even make this up. Which John has also visited with friends and or police, as well as streamed online. As disclosed in Brianna's 7/23/25 supplemental declaration filed before the DVRO trial, on 5/16/25, Brianna signed a lease in her solo name on an apartment in LA. Solo name, but who was there? She needed to get out of the MILF house immediately, but didn't want to sign a long-term lease without knowing what was going to happen with the DVRO trial. So the lease was only for 6 months and it expired 11/19/25, right before her travel to Texas to see W last month. I attached her last lease for reference. With her Texas trip and some subsequent travel after, she put her stuff into storage so she could house hunt upon returning from travel. She will have a new lease secured sometime this month. That's not what she says. Anyways, as your letter acknowledges, there are no pending requests for support or fees filed by either party on file with the court at this time, making your argument for those documents on this basis mute. Should John ever file one of those RFOs, discovering as to his income will be served immediately. Oh, they're right here. Hold on. I just have to get a cough drop because I'm going to lose my voice. This is a lot of reading. Okay, number 2. Okay. Number 2, no supplemental response will be provided. Brianna hasn't been served with any lawsuits. That's not true. She got served with a lawsuit from the MILF house. Anyways, they only hit for her name in LASC, which is Los Angeles Sheriff County. Criminal and civil system for 4/26/24. Present is this paternity case, which you could have paid $1 to search and confirm, like I did through LACS website. Her attorney is so petty. Hey, Jasmine. Brianna isn't involved in any other court cases for eviction, DV, or crimes. There are no pending requests for support or fees filed by either party on file with the court at this time, making your arguments about these documents on that basis mute. Should John ever file for one of those RFOs, discovery as to his income will be served immediately. RFOs, discovery as to his income will be served immediately. Of course. Oh, that's my screen recording. Okay. Hold on. I guess it only screen records for so long. Okay. Number 3, air travel. The demand seeks the same information as RPD3. Both are seeking Brianna's and or W's travel restrictions and reservations and itineraries for Brianna's travel to Texas for visitation with W from 4/26 to present. No supplemental response will be provided. The production period for this demand 4/26/24 to present makes it clear you're really asking Brianna's latest travel information, as anything prior to the DVRO. Thank you, love. Prior to the DVRO trial would be mute, as those issues were already litigated at the DVRO trial. You demanded the September information via email on 9/16/25. Failed to state a basis under which you were entitled to this information per the DVRO. And then when we wouldn't give into you served this discovery. This sequence of events illustrates the improper purpose behind this set of discovery. You're serving frivolous discovery for information you're not entitled to, costing both parties unnecessary attorney's fees, which is sanctionable conduct. Brianna provided her Airbnb address to John on OFW, that's our Family Wizard app, on 9/14/25 as required, far in advance of her visit. You then demanded round-trip flight information in and out of Dallas to confirm no travel reservations have been made for W, and we know what flight she'll be departing on if she fails to return him. And let me blow this up. The contact information and address where W can be reached, assuming she isn't planning to spend 24 hours a day, every day at the Airbnb. As a reminder, you guys, with her visitation, yeah, she has him for 7 days, and she can keep him the full 7 days. That's what she's been doing. But she can also do it to where she can say, well, I want him on Monday from noon to 6, and then bring him to me on Tuesday from such and such. She doesn't have to keep him overnight, so that's why she's saying that. I reminded you via email in my first response on 9/17/25 that there are no supervised visitation orders in place. She's not required to tell John daily what activities she'll be doing with W. Excuse me, sorry. Nor the addresses of those activities. And Winter was 17 months old at the time with no cell phone. No. And John already knows to use OFW to check on him, or if a true 911 to call Brianna's cell phone. I pointed out that per number 6 of the DV-145, Brianna is only required to provide itinerary-like information to John before traveling with the child, which she wasn't doing. Brianna also let John know on 9/15/25 on OFW that she was checking into the Airbnb a day early so she could get settled and get the place set up for W, a detail that wasn't required to provide, but did. You responded, the DV-130 includes kidnapping prevention orders on the last page. It does. Brianna needs to provide the address and contact phone numbers for where the minor child can be located during the visits, as well as round-trip flight information. It does. You then sent a second email 4 minutes later and alleged these demands weren't coming from John, but from, when she said you, meaning John's attorney. You said you were personally concerned about your client's ability to follow orders and am asking for the appropriate assurance as I have a professional obligation to my client. I do not want to be responsible if something happens to W during your client's week because I failed to ask for necessary information. I asked you what you were talking about on the last page of the DV-130 as page 10 of 10. That form doesn't contain orders about kidnapping, nor for Brianna to provide contact information for a 17-month-old, W's location or round-trip flight information. I reminded you I reminded you of the court's lack of, next page, appreciation for your position prior to the DVRO trial. That Brianna had to exercise her visits in a visitation facility despite never being the court's order. I said we didn't believe the court would appreciate you making up orders again, especially if that was being done this time to appease John based on your second email. I wish I had my orders up and I could just pull up the anti-kidnap order, because it does say that in there. I don't know why her attorney doesn't have that available. But anyways, your final response was to say you were done discussing this topic and you never answered my question about the DV-130, which is what you had based your demands for this information on in the first place. That response came in at 11:06 a.m. and you were served, and we were served with your discovery an hour later. You now argue this information is likely to lead to evidence re Brianna's request for W to live in California, but didn't explain this position. We don't understand the connection between Brianna wanting W to live here and... Wait, what? We don't understand the connection between Brianna wanting W to live here and her travel information, to and from Texas. Got it. You next argue this information is relevant to claims Brianna may have about difficulties traveling to and from Texas. It's no secret what those difficulties are or will be. As Brianna testified to the topic at the DVRO trial, traveling while pregnant is difficult, and having to pay for flights, a hotel, Airbnb, food, ride shares, and all of W's necessities that must be bought each time she's in Texas is expensive. I'm going to pause right there for a second. As she's in Paris right now, if Brie was just to rent a small apartment in Texas, even just a 1-bedroom, possibly a 2-bedroom, right? If she's going to go, it doesn't have to be anything fancy. It would be cheaper to do that than to rent an Airbnb each time. 1. 2, she could then see him twice a month, do like every other weekend instead of a full week, where she would then have the ability to actually establish a relationship with the child, and the child would be going to the same place every time, which would then also help him remember and have some sort of stability and normalcy. He would have his same room, his same toys. She wouldn't have to buy new stuff every single time. So Brie's putting that on herself. That has nothing to do with John or John's attorney. That's her. The absolute best thing she could do for her child is to do exactly that. She would save money, and it would be the best thing for her child. A 18-month-old child going 3 weeks without seeing somebody, no contact, no FaceTimes, no nothing, and then just getting dropped off for a whole week is absurd. But what do I know? Okay. Let me find where I was. Traveling while pregnant. Oh, yeah, we read that. Okay. John already knows this is from traveling to and from Texas and California himself, as evidenced by the spreadsheet you served prior to the DVRO trial for his expenses spent doing the same things. Seeing Brianna's airline travel reservations, airline travel itineraries, airline travel schedules is just to reach into Brianna's private life, especially because she has publicly announced numerous times that she rarely books her own stuff for privacy reasons. Her assistant or other third parties do. Sorry, I don't like to keep stopping, but it blows my mind when she talks about how she doesn't have money, she can't afford to do all these things, but yet has an assistant, she's traveling to Hawaii, Mexico, Paris, all of this other stuff, right, that she can do, but she doesn't have the money to do it for her child. It doesn't make sense to me, but nonetheless, let's just keep reading. Right, yeah, we're the broke ones. Considering John was somehow able to contact Brianna's latest Airbnb host through a third party without knowing who the host was initially, which we understand he denies doing, but we respectfully don't believe that. Doesn't encourage Brianna to share any of these details with John out of fear of him or people on his behalf trying to drag third parties into the party's drama. I'll just keep reading. As your letter acknowledges, there are no pending requests for support. Oh, this is the same as always. Yeah. Okay, law enforcement records. No supplemental response will be provided. You were already served with the LAPD and LASD documents when subpoenaed prior to the DVRO trial, the 325 drama, and had the ability to buy the same documents yourself from our deposition officer. Brianna wasn't arrested and or cited with any crime, thank you, love, on Catalina Island in June of 2025 and has nothing to provide. Well, she does, because Santos was arrested for DV, and again, it goes right back to it, but nonetheless, again, you could confirm her lack of trouble with the law like I did using LASC's name search in the criminal system. There are 0 hits on Brianna's name with no date providing, even using sounds like to ensure the search was overly invasive. We assume your reference to romantic partner to respondent and his criminal history is your 11/21/25 letter was a comment about Santos. Yep. Santos isn't a party of this case, nor is Brianna obligated to, nor has the ability to provide documents to John about a third party's criminal history. However, if you pay $1 to LASC's name search in the criminal history, you will see there are no cases on Santos here in 2025. Just because the parties share a child together doesn't mean either of them are obligated to disclose their involvement with law enforcement to their co-parent as you allege. This is an enormous reach. Based on your position, this would mean John must notify Brianna every time he calls the police on her when she's with W, which we both know has happened numerous of times. The calling of the police part, not him notifying her of the fact. Now, I bet you anything, if roles were reversed and John was dating somebody that was doing the same crap that Santos was doing, she would want that evidence. She would be bringing it up. But it's okay because it's Santos, I guess. I don't know. Okay, number 5. I'll just keep reading. This is the counseling. This is the parenting class, guys. And this is the one the judge ordered. No one else but the judge. The judge ordered her to do 12 weeks. And her attorney's response? No supplemental response will be provided. You've had Brianna's co-parenting / high conflict parenting class completion certificate. Great. She was ordered to take 12 weeks of parenting class, not a co-parenting class. From Cornerstone Counseling, signed by Scott, owner of the facility, since it was served on you 7/3/25. Brianna, 7/23/25 supplemental declaration discussed the details of this class and referenced her lodging and service of the certificate on 7/3/25. I shared the certificate with you on a second time via email on 9/2/25, attempting to meet and confer about the class meeting the court's requirements for a parenting class per the DVRO trial orders. Sorry, I thought I heard my granddaughter. You responded to my email 15 minutes later and said you'd look into it. Thus, you'd been sent what your 9/17/25 RPD requested twice before you served this discovery on us. So we're unsure why you're seeking the same document a third time. We don't know what else you're expecting Brianna to provide from her course completion, and this certificate is all Mr. whatever gave her at the time. She's requesting the 12 weeks of parenting class, not a co-parenting class. It's not difficult. Thank you guys all for hanging out with me tonight. I know it is late. I'm trying to get through. It's a whole lot. If you're new here, yes, this is a brand new filing. And if you guys aren't following me, just make sure you hit the follow button, hit the daily heart me. It's all I request. And just keep it cute in the comments, okay? Okay, number 6, travel to Texas. This demand seeks the same information as RPD 3. Both are seeking Brianna's and or W's travel reservation itineraries for Brianna's travel to Texas for visitation with W from 4/26 to present. This demand seeks the same information as RPD 3. Okay, no supplemental response will be provided. The production period on this demand for 26-24 to present, make it clear you're really asking for Brianna's latest travel information, as anything prior to the DVR trial would be mute, as those issues were already litigated at the DVR trial. You demanded the September information via email on 9/16/25, failed to state a basis under which they were entitled for the information per the DVRO, and then when we wouldn't give it to you, you served this discovery. This sequence of events illustrates the improper purpose behind, next page, this set of discovery. You're serving frivolous discovery for information you're not entitled to, costing both parties unnecessary attorney's fees, which is sanctionable conduct. Brianna provided her Airbnb address to John on OFW on 9/14/25 as required, far in advance of her visit. You then demanded round-trip information in and out of Dallas, and the contact information and address where W can be reached, assuming she isn't planning to spend 24 hours a day every single day at the Airbnb. I reminded you via email in my first response on 9/17/2025 that there are no supervised visitation orders in place. She's not required to tell John daily what activities she'll be doing with W, nor the address of those activities. And W was 17 months old time with no cell phone. She copied and pasted this from the other one, but I'll go over it. And John already knows how to use OFW to check on him, or True 911 to call Brianna's cell phone. I pointed out that per number 6 of the DV 145, Brianna is only required to provide itinerary-like information to John before traveling with the child, which she wasn't doing. Brianna also let John know on 9/15/25 on OFW that she was checking into the Airbnb a day early so she could get everything set up. You responded, the DV 130 includes kidnapping prevention orders on the last page. Brianna needs to provide the address and contact phone number of where the minor child can be located during the visit, as well as round-trip flight information. You then sent me a second email 4 minutes later and alleged these documents weren't coming from John but you. We already read this, so I'm going to skip past that. I asked what you were talking about on the last page of DV 130, as page 10 of 10 was of that form doesn't contain orders of kidnapping. And again, we read over all of this. It's a separate order. They have the DVRO, then they have the anti-kidnap order, and there's something else. I have them, and tomorrow what I'll do on my live is I'll go over them tomorrow. I'll post a video as well and put it all together. Your final response, excuse me, was to say you were done discussing this topic and you never answered my question about the DV 130, which is what you had based your demands on for the information in the first place. That response came in at 11:06 a.m. and we were served with discovery an hour later. You now argue this information is likely to lead to evidence re Brianna's request for W to live in California, but didn't explain this position. We don't understand the connection between Brianna wanting W to live here and her travel information to and from Texas. The next argue... Wait, what? Oh, you next argue this information is relevant to claims Brianna may have difficulties traveling to and from Texas. It's no secret what those difficulties are. Again, this is all the same. Talking about her being pregnant and how difficult it's going to be for her to travel. So I won't read that. As your letter acknowledges, there are no pending requests for support or fees. And again, we went over all of that. And she does say that there's not currently any request for child support, attorney's fees, etc. But all of that is done all that is typically done at the last stages of the custody, and that's coming up in January. That's why they're requesting it now. I'm not even an attorney, and I know that. She should know that. Okay, number 7. Third parties in Texas with Brianna. This is when he requested, excuse me, this is when they requested her to provide all verification of who travels with her into Texas. No supplemental response will be provided. John already has this information from 3:25 to 8:25, as Brianna was required to get John's permission for a third party to be present at her visitation. Let me see. At her visitation with W at the facility you forced her to use, and John only allowed her mom to be present once for the visits. I think she's confused. He's not asking who's at the visits. He's asking who's flying in with her. To claim that this isn't sufficient response because Brianna didn't sign off on this via verified response is absurd. Unless you're trying to allege that the facility Brianna used for her visits was allowing her to sneak in third parties to her visit without John's knowledge. Brianna also posted online during her Thanksgiving visit with W, showing her immediate family members with her and W at the Airbnb celebrating the holiday together. And the same was true for her September visit with W, showing her best friend Ruby there accompanying Brianna and W to the fair and other activities. Wait, so then it's okay for him to find out that information via social media instead of her reporting it to him? I'm confused. Right? Yes, these are brand new filings, you guys. These just came out. Hot off the press. That's why I'm up so late reading them. To claim these documents are relevant as to W's bond or lack thereof with friends or family members of respondent is absolutely ridiculous. If this is truly your position, then Brianna has a right to know who John has around W at all times, so she can make the same determination for the basis. But she can't, though, because she has no custody. She has 0 custody of the child. She only has visitation rights, no custody whatsoever. So she doesn't have that right. We suspect John would never be willing to divulge the level of detail about this custodial time with W. The only parties to this case are John and Brianna. Brianna isn't obligated to, nor has the ability to, provide documents to John that belong to third parties, such as airline bookings by said third parties. My screen recording keeps cutting off. Okay, record so I can get these up on YT for you guys quickly, but it keeps cutting off. Okay. The only parties to this case are John and Brianna. Brianna isn't obligated to, nor has the ability to, provide documents to John that belong to third parties, such as airline bookings by third parties. Also, this demand is really not asking for documents, but disclosure of those who have been in Texas with Brianna, which isn't appropriate for the RPD for a special, but for a ROG. Additionally, we discussed this via email 10/15/25. You threatened an ex parte RFO during my notice period of unavailability per my notice of unavailability pleadings filed and served on 10/7/25. I explained that Brianna isn't prohibited from flying to Texas with Santos, as Brianna's flight to her visitation location isn't visitation, and the orders only prohibited Santos from being present for Brianna's visitation with W. Thank you, love. Response to number 8. This is parties sharing household. No supplemental response will be provided. This demand is really not asking for documents, but disclosure for anyone who has lived with Brianna, which isn't appropriate for an RPD, but for a special ROG. If and when Brianna ever has a roommate living with her, did she just lie to the court? Santos has been living with her. What does she mean? If or when? If or when Brianna ever has a roommate living with her, she will file and serve an updated UCCJEA form as required by law to update W's residency information with the court. We know John hasn't met his legal obligation on this point, as his only UCCJEA on file only lists Brianna's address in DTLA, where she was living when W was born. RPD 9. This is the relocation documents. No supplemental response will be provided. Brianna has been very vocal online about her intentions to remain living in LA. I'm so confused on this. So she doesn't have to provide it through the court because she says it online. So that's just how it is. That's how he needs to get the information. Don't watch her, because if you watch her, then you're stalking her, you're doing all those things, right? He's like all up in her business, stalking her, etc., right? But she doesn't have to provide any information because she said it online. That doesn't make sense to me. I can't believe she even said that in a court document. Anyways, I will keep reading. No supplemental response will be provided. Brianna has been very vocal online about her intentions of remain living in LA, which is where she has now lived for the past 8 years since turning 18. This demand is really not asking for documents, but disclosure of Brianna's residence plans, which isn't appropriate for an RPD, but for a special ROG. You allege these documents are relevant to the move away issue, but it's John seeking to make W a resident of Texas, not Brianna seeking to move away with W. You also claim these documents are relevant to the paternity case without further explanation. And again, it's your client seeking the move away order, not mine. Did you hear that, Bree? There is a move away order, Bree. Because she really thinks that there's no move away order. Okay, number 10. Correspondence Ari about, this is the one about any correspondence she has in regards with other people in regards to John or W. Shocking. No supplemental response will be provided. We stand on our objection on this one. John has absolutely no right to Brianna's private communication with third parties. None of these people are parties to this case. So, sorry, hold on. So they also have, none of these people are part of this case, so they also have their own even stronger privacy rights. You also generically ask for correspondence and documents without defining a single a single subject area of conversation who we're expecting to get. Thus, full compliance with this demand would include text between Brianna and her DoorDash driver about a necessities delivery to the Airbnb for W. Airbnb, really. Just one example of the laundry list of communication that would be wholly irrelevant to these proceedings, and producing the same would be extremely intrusive into Brianna's private life. Remember, if you're going to assert positions as outrageous as those stated in your letter about this demand, you're applying these positions to both parties. Would John turn over all of his communications with his mom's friends or girlfriends about Brianna? Would John agree that how he communicates with those third parties has a bearing on his co-parenting relationship with Brianna? I think we both know the answer to those questions from your client would be a hard no. Snippety. Sheesh. Number 11. Impediments to ability to travel. No supplemental response will be provided. As mentioned under RPD 3 above, it is no secret what the difficulties are and will be for travel to and from Texas. As Brianna testified to this topic at the DVRO trial, traveling while pregnant is difficult. Well, she traveled to Paris just fine, didn't have no problems. But I'll move on. Traveling while pregnant is difficult, and having to pay for flights, a hotel or Airbnb, food, ride shares, and all of winter's necessities must be bought each time she's in Texas is expensive. John has zero rights to Brianna's medical records about her pregnancy, and none will be provided. But she's the one that brought it up. She's the one that said, I'm pregnant, I can't do it. So I'm confused on that. So the court, everyone just takes her word on it? Because mind you, she said this, back in August, September. So she's going to show up to court in a couple weeks with still a flat tummy. And the judge is going to be like, wait a minute. You're supposed to be doing March. You know what I'm saying? Or July. Okay, thank you. Number 12. Travel within Texas. No supplemental response will be provided. We stand by our obligation on this one. John has absolutely no right to Brianna's private communication with third parties. None of these people are parties to this case, and they also have their own, even stronger privacy rights. Furthermore, Brianna dropped her Thanksgiving idea at her mom's house in Corpus Christi after you and John refused to consider that idea, and had her family come and visit her and W at the Airbnb instead, making any correspondence about the plan completely mute. There has been no discussion between the parties or counsel about any Christmas plans outside of Dallas County because there aren't any. The parties agreed on 9/2/25 that the dates of, I don't ever like to release dates on when she has him, but there's dates on there when she'll have him. I just don't like that. So somebody will put it out there. I just don't like to. You argued that a child's relationship with the community and or family members is part of the Lamuguska analysis, but that topic isn't on the list of factors in Lamuska. John made sure Brianna didn't have the opportunity to bring W to her family's home base in Corpus Christi, so they came to her. Family time is still bonding time regardless of location. And again, in all bold, red, underlined note, she put, if you proceed with filing a motion to compel further responses, we will respond with requesting at least $10,000 in sanctions. Exhibit G. Let me take a quick drink. Oh, yeah, I agree. Yeah, all of this is up to... all of this is because of Brianna's own action. You were 100% right. Okay. This is John's attorney's response via an email. Hi, Lindsay. we will be filing a motion to compel, as it is clear from your letter your client is not willing to provide any verified substantive responses. Correct me if I'm wrong. You seem to be fixated on the fact that you and I exchanged emails on the same day as we propounded discovery. The discovery propounded is related to the issues in this parentage case generally, which I remind you is still prejudgment. So all issues, custody, visitation, child support, attorney fees, all remain ripe for discovery. I love her. The fact that I asked for the voluntary production of certain documents in an email and you refused to voluntarily provide them does not negate your client's obligation to respond in good faith to discovery. The demands are appropriate given all of these issues for which we do not yet have final orders in the parties' parentage yet. Your purported descriptions of some of the information related to the documents sought by the demands is not helpful. This information in your letters and you are seeking objections set forth in the original responses does not resolve your client's obligation to respond under penalty of perjury. If documents do not exist, she can say as much in a verified response. If documents are too bothersome for her to gather, she can let us know where we can obtain them in a verified response. If documents exist, but she's lost, misplaced, or destroyed them, she could say so much in a verified response. As a reminder, CCP section 2017.101 provides, unless otherwise limited by order of the court in accordance with this title, any party may obtain discovery regarding any matter not privileged. This is relevant to the subject matter involved in the pending action or to the determination of any motion made in that action. If the matter either is itself admissible in evidence or appears reasonably calculated to lead to the discovery of admissible evidence, discovery may relate to the claim of defense of the party seeking discovery or any other party of this action. Sorry, I'm getting tired, so I'm reading slower. Discovery may be obtained of this identity and location of the person on screen recording. Discovery may be obtained of the identity and location of persons having knowledge of any discoverable matter, as well as the existence, description, nature, custody, condition, location of any documents electronically stored, information, tangible things, or land of other property. Please refer also to the following relevant case law. I'm not going to go into all of the case law. I am concerned that your client's refusal to provide verified, substantive responses and produce documents is not made in good faith, and it is intended solely to obstruct my client's right to conduct discovery related to the issue in this case. I would agree. You have completely ignored all of the demands. You are claiming that documents related to your client's relocation plans or where your client resides are not relevant to a move-away issue when one of the Lamuguska factors is the distance between each party's residence. You are claiming that documents evidencing your client's travel and ability to travel is not discoverable when the court is going to be tasked with establishing a final parentage plan pursuant to which parties which the parties and their child are going to be required to travel and arrange for someone else to travel for exchanges. You are claiming your client doesn't need to disclose law enforcement records, which would include those related to DV incidences between her and her current live-in boyfriend, as though Family Code Section 3044 does not exist. My initial meet and confer letter sets forth these issues more thoroughly. This is my last attempt to resolve these issues before filing my motion to compel. I plan to file first thing Monday morning, 12/12/15. Yikes. No. Ooh, shake what your mama gave you. We're almost done, guys. Hang in there. We got 4 more pages. We're almost there. Thank God, because I don't think my throat's going to hold out much longer. Okay. So, petitioner's memorandum of points and authorities in support of motion to compel further further responses and production of documents responsive to demand for production of document set 1. So this is John's attorney's motion to compel that was filed. She said I fell asleep, page 40. I'm sorry, love. We're almost done. Okay. To the court and the respondent, Brianna Lynn Olson, and her attorney of record. Petitioner John Giese, by and throughout his attorney of record, Taylor Budnick, love her, hereby submits the within memorandum of points and authorities in support of petitioner's motion to compel respondent to serve her verified responses and produce all responsive documents without objections to petitioner's demand for production of documents set 1. That's the DFP. An award of petitioner's attorney's fees and costs payable to respondent as discovery sanctions pursuant to Code of Civil Procedure, blah, blah, blah. Okay, authority. A. The court has authority to compel respondents' supplemental verified responses and production of responsive documents on the basis that the objections served by respondents' counsel are too general and or without merit. Code of Civil Procedure 2031.310 provides the court with authority to compel respondent to serve her verified responses and produce all responsive documents to petitioner's demand for production of document set 1. Specifically, this section provides in pertinent part A. On receipt of a response to a demand of inspection, copying, testing, or sampling, the demanding party may move. Thank you, Nunu. The demanding party. Where was I just at? The demanding party may move for an order compelling further response to the demand if demanding party deems that any of the following apply. 1. A statement of compliance with the demand is incomplete. 2. A representation of inability to comply is inadequate, incomplete, or evasive. 3. An objection in the response is without merit or too general. Here, as set forth in the declaration of petitioner's attorney and the separate statement filed concurrently here within, the objections served by respondent's counsel are too general and without merit. Indeed, not a single substantive response was provided, nor nor were any documents produced in connection with the respondent's response. B. Petitioner has complied with all procedural requirements in noticing the instant motion of compel. A motion of compel filed pursuant to CCP section 3021.131. Thank you, Nunu. Shall set forth specific facts showing good cause justifying the discovery sought by the demand. The motions shall be accompanied by a meet and confer declaration under section 2016.040. The declaration of petitioner's attorneys filed concurrently herewithin describes the efforts to meet and confer with respondent through her counsel to obtain substantive verified responses and production of the requested documents from respondent to no avail. As set forth therein, respondent refused to provide any substantive verified responses whatsoever, despite petitioner's attempt to meet and confer with respondent's counsel about the impropriety of her objections to her clients providing any substantive verified responses to the documents. As of the date of preparation of the herein motion, respondent has failed to serve any substantive verified responses or produce requested documents in response to petitioner's demand for production of documents set 1. Petitioner's separate statement is filed concurrently herewithin, which set forth each discovery response and each response in dispute. Notice of the instant motion is being provided within the statutorily required time frame. CCP section 2031.310 verifies, unless notice of this motion is given within 45 days of the service of the verified response or any supplemental verified response, or on or before any specific later date to which the demanding party and the responding party have agreed in writing, the demanding party waives any right to compel a further responsive demand. Here, respondent has failed to serve verified responses. In any event, as discussed in the declaration of petitioner's attorney filed concurrently herein, notice of the instant motion is being provided within 45 days of the agreed upon deadline for petitioner to file his motion to compel. Should the court deem the 45-day deadline applies to service, service of any unverified responses consisting solely of objections. C, we're almost done, guys. The imposition of monetary discovery sanctions against respondents is mandatory under the circumstances. The court is required to impose monetary sanctions against respondent if she unnecessarily opposes the instant motion to compel. Absent of finding that respondent acted with substantial justification or other circumstances make the sanction unjust. Here, the respondent refused to serve any substantive responses whatsoever, including after a meet and confer letter was sent. There is no justification for respondent's outright refusal to comply with discovery, nor are there any other circumstances that would render the imposition of sanctions against respondents unjust. An award of petitioner's attorney's fees as sanction against respondent are also warranted under CCP section 2023.050. This section provides, in pertinent part, notwithstanding any other law, and in addition to any other sanctions imposed pursuant to this chapter, the court shall impose a $1,000 sanction payable to the requesting party upon a party, person, or attorney if, upon reviewing a request for a sanction made pursuant to section 2023.040, if the court finds the party, person, or attorney did not respond in good faith to an inspection demand made pursuant to section 2031.101. The declaration of petitioner's counsel finds concurrently herewithin sets forth petitioner's attorney's fees incurred in connection with respondent's failure to serve substantive verified responses and produce requested documents responsive to petitioner's DFP. As set forth above, an award of attorney's fees, the petitioner as discovery sanctioned for respondent's failure to serve response is mandatory under the code. Conclusion, we're there, guys. Based on the foregoing, petitioners respectfully request that the court grant his motion to compel and order respondent to pay his attorney's fees incurred in connection with bringing the instant motions as discovery sanctions against respondent. Respectfully submitted. Page 90. Wow. So that was a whole lot of. And first of all, shout out to you guys. We still have 876 people that have held on this long. I appreciate you guys. And 217,000 likes. And a kiss from Pup Mom. You guys are amazing. Stretch your fingers out. Oh, Rita, it's a new, thank you guys for the claps and the love. I so appreciate you guys. A new filing from Brian 2K. It was very long. So, oh my gosh, I know it's so, thank you, Nunu. I know it is so late for you guys, so I won't keep you guys long, but I'm going to say this. I'm going to download this, and I will put it on my YT. I'm also, thank you, Nunu. I'm also going to, probably tomorrow, like maybe when I have the kids down for a nap. Oh my gosh, it's 7:34 in the morning in the UK. Holy crap. I'm also going to break this down, and I'll do videos breaking down kind of each part, so it won't be so long. So it'll be like a lot of videos. It'll be multiple parts, but I'll be breaking it down so it'll be a little bit better for you guys to understand, especially because as I'm old and my eyes are tired. I'm tired, so my reading got slow. So yeah, absolutely. I can pin my YT. My YT is the same as my, what's this called? Same as my TikTok. So if you guys are not already following me, please make sure you guys follow me here, because I will keep you guys abreast and updated. I am only following this case to conclusion. Right? Once court is done and everything is done, then I will be done following this case. I won't be taught. Brian Santos bore me to no end. Right? So I won't be continuing. But I will follow all the way through. So if you guys have questions, whatever, make sure you come back. I know there was a break. I was super sick for about 2 weeks. I'm kind of at the tail end. But I will make sure I stay abreast on all of this. So I just wanted you guys to know that. I appreciate you guys so much for hanging in here with me tonight. This case is far from, I know, that's what I'm worried about, love, is it's far from over. I really was hoping that, it's going to be over. A few things though, I did go back over and read the transcript a while ago. Actually, it's probably it's probably like the third or fourth video that's on. All my videos are marked if you guys don't follow me. Where I went back over and I reread the transcript and some of the discovery stuff. And I found in there, it said, if she completes the 12 weeks of parenting class, and if she still resides in California, they may consider her being able to have visitation in California. Well, that's why they're asking her so much about her residence. She does not currently have residence in California, and she never completed the parenting class. She completed a co-parenting class, and even her attorney just admitted it in here, right? But the most important thing that I found was it said that Santos cannot be around under any circumstance, right? Under any circumstance, yeah. So I went into the California state law system. Thank you guys for subbing over there. I went into the California state law system. Capacity, that's what it is. Oh, I'm so tired. Capacity, in any capacity. So I went into the California state law and I looked that up. What does that mean? And it broke it down, and I read it to you straight off of the website. That video is on my page as well, so you guys can read that up. But in just basically what that means is he cannot be part of the planning of the visit, the traveling. He cannot be a part of, not just when she has W. Say she has somebody visit. Like, for instance, this last time when they went to the club and someone else watched the baby, that's a violation because he was a part of the visit in some capacity. They said he cannot be outside of the house, in the car, in the yard, at the same store. He cannot be around in any capacity. So even just the club appearance very well could be a violation of the DVRO. Him coming and picking up Chrome. Remember how, he accidentally went live and showed that he was at the same place. Then they said that they had 2 Airbnbs, but they would be gone and he would come pick Chrome up. That's a violation. FaceTiming, that's a violation. It clearly lists it all in that. And again, I have a video up that's about that. So now that I'm feeling a little bit better, I will get back to making videos and really kind of diving into this, especially now that we have this. I will make sure I get all of this up. So I don't want to keep you guys long because it's already a very late night and I'm so thankful. Yeah, bringing the food, violation. All of it. Yeah. You guys, I know people are garbage. A lot of people say that. People think that the judge needs to be taken off or if she listens. This is my thought process on the judge. So hear me out. I personally, I like the judge, right? And I've seen this happen in some of my cases in the past. When she was going through the supervised visitation, and this is why I've always said that I don't really care much for supervised visitation because it's not a realistic setting, right? You just have someone sitting there just taking notes every couple minutes. It's not a realistic situation. She's not having to make lunch or make dinner or whatever because it's only for the 2 hours, right? So, and the judge literally said it. Okay, you want to be a parent, you want to have lunch, perfect. You have him. You get him for 7 days. Now, mind you, she did not want to do the 7 days straight. She wanted every other weekend because she knows that that's what's best. But because Brianna said it was too expensive for her, that's why she did the 7 days. But she said, I'm assuming you have learned something. So I have a feeling that you're going to have these visitations and you're going to do better. There's not going to be one issue. There's not going to be any concerns about, Santos being there or you doing this, that, or whatever. Because if you do, I know it'll be put online. And if you put it online, it's going to come back to me and you're not going to like the outcome. So the phrase that I use, which is not the best phrase, is basically like, you want to do it? Okay, here you go. Here's your parenting time. Here's the rope. Either use it to pull you along or hang you up. You know what I'm saying? That's truly, honestly, how I feel what the judge is. The judge had to give her time basically to hang herself. So we will see. We will see what's going to happen. I don't know. But that's what I believe. I think she's a good judge. I think she's fair. But what do you say to just supervised visits for 2 hours? You know what I'm saying? So I don't know. Okay, guys. I'm exhausted. And I got a sick grandbaby that I got to watch tomorrow. I'm still getting over it myself. So I'm going to get some sleep. Thank you guys for hanging out with me for so long. Thanks for coming back. As we did an hour and a half, and then I got the kids to sleep, and we came back, and so we've been going on for almost 3 hours now. 90 pages is a whole lot. I appreciate you guys so much. I love you guys too. I will get it broken down a lot better. I'm going to download this overnight, and I will post it first thing in the morning over on my YT. Make sure you follow me here and over on YT. Have a great night. I love you guys. I'll see you tomorrow.